President of the Law Association, Dr. Lynette Sweet, distinguished members of the DRC Arbitration Committee, Mr. Gurley, distinguished Senior Counsel, Dean of the Faculty of Law, Dr. Elias Roberts, representatives of business entities, members of CIARBTT, and the legal profession. On behalf of our chairman, Dr. Justice Anthony Gafuru, who unfortunately is unable to be here with us today, and the executive of the Trinidad and Tobago chapter of CIARB, we welcome you to this important event commemorating the Proclamation of the Arbitration Act. I wish to acknowledge the support given to us by the Honorable Chief Justice, Mr. Justice CIARBTT, ORTT, in making available to us this venue, together with the necessary technical resources. You will note from your program provided in the registration package the order of items. Unfortunately, the Honorable Chief Justice is unable to be here in person, but will bring remarks by way of a recorded video message. Similarly, Senator the Honorable Reginald T.A. Amo as Senior Counsel, Attorney General and Minister of Legal Affairs, was very urgently called upon to deal with government business and cannot be here. He too will bring greetings by way of recorded video message and extends his deepest apologies to everyone for not being here. He really wanted to be here, but things are the way it goes, as you know. In an effort to move smoothly through our program, after the video recordings, Dr. Lynette Sweet will give her remarks immediately after, and we will begin with 3 presentations. Having provided the bios for our presenters, there will be no introductions, but rather each presenter will move directly into their presentations. You will note from the program there is to be a short break, but this is merely to facilitate miking for the question and answer segment, and so we ask you to remain in your seats because we would like to very quickly cover as much material as we can in the short time that we are here. So I will now ask for our technical team to do the needful in relation to the 2 video recording messages.
Good afternoon. I am pleased to bring brief remarks to this gathering, along with apologies for my unavoidable absence. The understanding and deployment of arbitration as a tool for settling disputes, particularly in the commercial realm, is a critical part of the strategy for reducing backlogs and making Trinidad and Tobago a more attractive place to do business. As arbitral proceedings arise out of a contractual agreement, it provides parties with the ability to engage a process that is more suited to their commercial reality and to reap the benefit of subject matter expertise that is not always available from general jurisdiction judges. From my point of view, the more complex the matter, generally speaking, the more suited it is for arbitration. Apart from the relief that it can bring to overloaded court dockets, if properly managed, there can be improvements in efficiency, and in the commercial world, time is money. In the context of the Proclamation of the Arbitration Act No. 11 of 2023, the key consideration for the judiciary is the role that the courts would play in this process moving forward. Our role is both to interpret the Act and to uphold a process for solving disputes that will inspire confidence, minimize the need for more formal, complex, and expensive litigation, and at the end of the day, provide effective remedies. The Arbitration Act 2023 is a commendable effort to bring this form of alternative dispute resolution in step with modern realities in the commercial world, not least in the way in which it accommodates universal acceptance of electronic documentation and communication as business is increasingly conducted in digital spaces. Contracting parties to any agreement generally have the autonomy to agree to the terms and conditions in their contract. Arbitration is a form of alternative dispute resolution and is a process that reinforces the concept of party autonomy. Therefore, subject to constitutional and public interest limitations, which might themselves generate some interesting litigation, the Act reinforces the principle of non-interference by the courts, whose duty is to enforce the express provisions of the Act while giving due regard to the wishes of the parties and the provisions of the arbitration agreement. While the legislation permits the court to examine the applicability of an arbitration agreement, we are enjoined to take actions that support the arbitration process. Central to that role is to promote the objects of the Act as stated in Section 5. It is to be noted that the word facilitate appears 4 times in that section. It is indicative of the posture that we are required to adopt. In discharging that mandate, judges would need to be familiar with the provisions of the new Act and, to the extent that it can be facilitated by our laws, interpret agreements in a way that is consistent both with our domestic law and international norms and practice, particularly as they find expression in UNCITRAL, which is expressly adopted. Where it will get interesting is when the state is a party. What, for example, are the kinds of challenges that would arise with an issue related to taxation? To what extent would such an arbitration agreement be deemed permissible by the courts? In his writing, Justice Anderson has raised the question whether there is in an arbitration agreement an implied authority for a party to contract out of a constitutional right. Can it collide with legislation that requires transparency? I pose these rhetorical questions simply as examples of how the local judiciary may in the future be called upon to bring clarity. Overall, the Act permits greater integration of the local regime governing arbitration with established international practice. One must never lose sight of the fact that an independent, impartial, and competent judiciary is a critical part of our economic infrastructure. It would be correct to say, on the surface of it, that this legislation will assist in the development of international commerce in Trinidad and Tobago by allowing the judiciary to support arbitration as it pertains to international commercial contracts. The responsibility of the judiciary to administer justice is not at odds with the principles of ADR and the benefits to be derived from this legislation. The issue is, as in all things new, the need to ensure that implementation is effective, efficient, and just. To do so would require, as well, the need to develop the required technical skills. While we have a significant number of certified arbitrators in Trinidad and Tobago, there will arguably still be a need for the training of additional persons, as well as continuous professional development for those who are trained as arbitrators. In this regard, the judiciary, through the Judicial Education Institute of Trinidad and Tobago, can partner with the Trinidad and Tobago chapter of the Chartered Institute of Arbitrators to facilitate training under the new statutory regime. I expect that this is only the first of a series of events to sensitize all stakeholders as we advance the ease of doing business by reducing costs, hopefully, and increasing efficiency and transparency as it relates to protecting the rights of parties in commercial relationships. I applaud this effort and I wish you all success in a new beginning. Thank you for your attention.
It is my distinct pleasure to bring greetings in recognition of the Arbitration Act 2023, proclaimed approximately 3.5 months ago in February 2024. The Act heralds the introduction of a modernized legislative framework for arbitration in Trinidad and Tobago. It is noteworthy that this Act has moved Trinidad and Tobago from an antiquated legislative landscape originating in 1939 to a restructured, globally accepted statutory structure that reflects the requisite features and needs of international commercial arbitration as well as international arbitration practice. This Act adopts the United Nations Commission on International Trade Law, the UNCITRAL Model Law on Arbitration, which is the internationally accepted model. Trinidad and Tobago now has the distinction of being one of 125 jurisdictions to have promulgated legislation based on or influenced by the UNCITRAL Model Law. I state for the record that the Trinidad and Tobago chapter of CIARB has in the past supported the adoption of the UNCITRAL Model Law on International Commercial Arbitration, inclusive of recommendations by the Arbitration Committee of the Trinidad and Tobago Chamber of Commerce and Industry to the Office of the Attorney General and Legal Affairs. The Trinidad and Tobago chapter of CIARB further contributed to the 2019 and 2021 drafts of the arbitration bills, which ultimately led to the introduction of the bill and passage of this Act. I applaud the Trinidad and Tobago chapter of the Chartered Institute of Arbitrators, CIARB, for hosting this seminar in the wake of the recently proclaimed Arbitration Act. An event such as this will undoubtedly aid in building general awareness and exposure to the Act amongst attorneys at law, professionals in various industries, energy and construction, business community, chambers of commerce, and small and medium enterprises. Within the last decade, there has been a growth of international arbitration centers across the Caribbean, signaling a trend in favor of alternative dispute resolution methods as a viable tool of dispute settlement. Given that we've now modernized our arbitration architecture by passing this Act, this is the opportune time to contemplate establishing an arbitration center in Trinidad and Tobago. We are well suited to establish an arbitration center given our unique geographical position, placing us in proximity to Latin America and outside of the hurricane belt. Trinidad and Tobago is a hub for various industries such as shipping, manufacturing, energy, and construction in the English-speaking Caribbean. The volume of economic activity and the notable presence of multinational companies as well as small and medium enterprises highlight the need for an effective and accessible dispute resolution method which can be facilitated through an arbitration center. The establishment of this center can also increase investor confidence and promote the ease of doing business within our shores. Trinidad and Tobago's existing infrastructure is an ideal starting point to facilitate an international arbitration center. The Port of Spain International Waterfront is ideally placed for such an initiative. In the implementation of this Act, continued capacity building amongst legal practitioners is necessary. The Trinidad and Tobago chapter of CIARB can support this goal by continuing to fulfill one of its primary mandates, which entails providing education and support for arbitration and alternative dispute resolution, ADR processes. This will aid in increasing the cadre of local attorneys who, through their CIARB membership and training, will be equipped with the requisite knowledge and skills. In establishing an arbitration center, it is imperative that one of the CIARB London centenary principles on legal expertise is promoted fully. That principle provides an independent, competent legal profession with expertise in international arbitration and international dispute resolution, providing significant choice for parties who seek representation in the courts of the seat or in international arbitral proceedings conducted at the seat. As legal practitioners, we must be open to avenues outside of litigation to resolve disputes. It is crucial that we include litigation and transactional lawyers in the discourse so as to demonstrate the potential economic and professional advantages of arbitration. ADR practitioners should also commit to assist them to understand arbitration so that they can build an arbitration component into their practice. There should also be an ease of locating arbitrators within our jurisdiction, perhaps by creating an online register of arbitrators, which clients, attorneys, and professional bodies can utilize to verify arbitrator credentials and areas of expertise. Too often when we hear the words Caribbean arbitrator on internet search engines, the results are not in fact persons who reside in or were trained in the region. We have to make it easier to raise the profile and increase the visibility of local arbitrators. In the world of international commercial arbitration, it is widely known that the field lacks diversity, as can be seen by the large majority of individuals chosen to serve as arbitrators being male from North America or Western Europe, and generally very senior persons. We must be motivated to make arbitration more diverse and inclusive. It is not enough to train local attorneys in arbitration. We should also endorse our local talent pool by considering them as arbitrators where appropriate. We should not wait for the world of international commercial arbitration to see the value in diversity. We must recognize it for ourselves and in ourselves. We must recognize that local arbitrators may view a dispute with a unique perspective. We ought to ask ourselves whether a selected international arbitrator from the typical background may yield a different perspective. We must ask whether a lack of diversity can deny parties to arbitral proceedings the benefit of perspective. One of the recommendations following the arbitration conference hosted by my office in December 2023 was the need for judicial education about arbitration and arbitration issues that may come before the courts. In this regard, I look forward to the discourse of the Honorable Madam Justice Permanent, Justice of Appeal, on the topic Judicial Support for the Arbitral Process under the Arbitration Act. Further, it is overdue that we endeavor to bring awareness of arbitration to law students. Perhaps it is time that there be consideration for the incorporation of an arbitration course in the syllabus of the regional law schools and universities. A culture of arbitration should be fostered amongst future legal professionals by encouraging participation in international competitions and international internships. If I may be permitted in suggesting that there may be consideration of the Trinidad and Tobago chapter of CIARB partnering with the Faculty of Law, the University of the West Indies, St. Augustine, and the Hewardin Law School to host training seminars and mock arbitrations with the aim of exposing and sensitizing students to the arbitral process. With the proclamation of the Arbitration Act 2023, Trinidad and Tobago has established a necessary legal infrastructure that will enable us to capitalize on the increasing demand for international arbitration in the Caribbean. The Act now paves the way for an establishment of an arbitration center in our jurisdiction. I wish to emphasize that this Arbitration Act has brought this country's arbitral regime in line with international best practices. This augurs well for opportunities and benefits for trade and investment. In closing, I take this opportunity to signal the support of my office as steady gains are to be made in facilitating domestic and international trade and commerce by encouraging the use of arbitration as a means of resolving disputes. Thank you.
Of the protocols articulated by Chartered Institute of Arbitrators, Trinidad and Tobago Branch Secretary, Ms. Salma Rahman, especially in light of the necessary brief allotment of time awarded to someone simply bringing greetings, albeit from the Law Association of Trinidad and Tobago. It gives me great pleasure to accept such an invitation from someone who is a dear friend and longtime collaborator in other spheres of activity, in addition to being a former and indeed the first associate of Lynette C. Brown and Company way back in 1992. And I dare say, Salma, that I'm giving away vital personal information on both of us with such a dating. It was also a pleasure, it is also my pleasure to give special recognition to the president of the Institute, His Honor Dr. Justice Anthony Gafoor in absentia, another dear friend and collaborator in other spheres. One of my earliest assignments as a young attorney, outside of the strict practice of law as a litigator, was to give lectures to engineers in the Faculty of Engineering at the University of the West Indies on the process of arbitration and necessarily on the whole Arbitration Act. But I must confess that apart from informally advising Professor Emeritus Sweet, who has on numerous occasions himself acted as an arbitrator, today bodes well for being a deep learning exercise for me and other members of the legal and other professions here. The etiquette of bringing remarks demands that one should not stray too much into the subject matter, lest one treads on the material to be more fully and expertly presented by our knowledgeable and distinguished presenters, such as Justice of Appeal Pemberton, Mr. Ian Benjamin, Senior Counsel, and of course, Ms. Rahman, and thereby to risk both repetition and superficiality. Suffice it to say that the Law Association fully endorses and recognizes the significance of the passage of the new Arbitration Act number 11 of 2023, which repeals Chapter 35 of 1996, originally passed way back in 1939 and itself based on an 1889 model inherited from England. The objectives of the new legislation are most laudable, and the legislation is predicted to have a positive effect on direct foreign investment, to encourage small and medium enterprises to have confidence in the arbitration process, and to make arbitration itself more affordable, more amenable to experts acting as arbitrators, and to open up a wealth of training opportunities for Trinidad and Tobago professionals across the board. It also limits the legislation, in my understanding, the intervention, the potential for the various interventions by the court into the arbitration process. And it provides for arbitrators now to decide on their own procedure and even their own jurisdiction. And of course, there are many other improvements to the legislation which will be elucidated upon during the course of the afternoon. The Law Association is planning its first Law Week and Law Conference for the week of the 7th to the 11th of October 2024. And I will be reaching out to you, Salma, and to the Institute, as well as to some of the distinguished presenters here today, to participate in the commercial panels planned for that event. It is with great pleasure that I bring these greetings from the Law Association of Trinidad and Tobago, and I offer our best wishes for a stimulating and informative afternoon. Thank you.
Good afternoon once more. I'm going to get straight into the Act, and the key features of the Act is the topic of my presentation. Now, arbitration is the most traditional form of private dispute resolution with a long history spanning several hundred years in the commercial sphere. It results in a binding and enforceable determination of a dispute and is conducted with the consent of the parties, with the parties making a selection of their arbitrator or arbitrators. There is neutrality, particularly in the case of international arbitration. The process is private and confidential, and it results in finality of the award. Arbitration is driven by a contract or commercial engagement in which they agree that if a dispute should arise, they will not use the formal court system. Instead, they will submit their dispute through an arbitration process using an arbitrator or arbitrators to determine their dispute. The underpinning for governing the private dispute resolution process is the arbitration agreement. As has already been identified, the new Arbitration Act adopted the UNCITRAL model law on international commercial arbitration and closely followed the CARICOM Model Arbitration Bill 2022. It is necessary for me to lay a foundation for the benefit of all the presentations which follow today to highlight the broader regulatory landscape for international arbitration. International conventions are the most effective method of creating a universal system of law governing international arbitration, as they have helped to link national systems of law into a network of laws that have as their common objective the international enforcement of arbitration agreements and of arbitral awards. International enforcement of awards ensures that the successful party recovers the proceeds of an arbitral award wherever the assets of the losing parties may be located in the world, regardless of differences in legal systems. So you see, I have a little timeline there, 1958. The United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, otherwise known as the New York Convention, serves two purposes. One, it requires the recognition and enforcement of arbitration awards in foreign states. And two, it requires national courts of signatory states to recognize and protect arbitration agreements. The New York Convention was ratified by Trinidad and Tobago on the 14th of February 1966, and on the 19th of November 1996, the Arbitration Foreign Arbitral Awards Act, Chapter 530, came into force, a copy of which was included in your registration package. Next in the timeline is 1965. The International Center for Settlement of Investment Disputes, otherwise known as the ICSID Convention. This convention is the new arbitral forum for the resolution of disputes between investors and states. The International Center for Settlement of Investment Disputes gave both private individuals and corporations who were investors in a foreign state the right to seek redress against that foreign state by way of arbitration before the International Arbitral Tribunal. The ICSID Convention was ratified by Trinidad and Tobago on the 3rd of January 1967, and on the 17th of June 1996, the Investment Disputes Award Enforcement Act, Chapter 503, came into force. Then in 1985, the UNCITRAL model law was adopted on the 21st of June 1985 and amended on the 7th of July 2006, and is now adopted by our Act. And of course, there's the revised Treaty of Chaguaramas 2001, which by Article 223 required member states to encourage and facilitate the use of arbitration as a preferred method of settlement of disputes. So this is the legal framework for arbitration in Trinidad and Tobago now. It took us 27 years since becoming a signatory to the New York Convention. And after 38 years of coming into existence of the UNCITRAL model, we can now say that we are now on board with the rest of the world. Now, the UNCITRAL model law is specifically designed to assist states in reforming and modernizing their national arbitration laws, and has been accepted and implemented across divergent legal and economic systems. It can and frequently is adapted to apply to domestic as well as international arbitration, and this is in keeping with the Uncitrul Secretariat's recommendation, which states, while the modern law was designed with international commercial arbitration in mind, it offers a set of basic rules that are not in and of themselves unsuitable to any other type of arbitration. States may thus consider extending their enactment of the model law to also cover domestic disputes, as we have now done. Now, since the adoption of the Uncitrul model law, the model law has come to represent the accepted international legislative standard for modern arbitration, and a substantial number of jurisdictions have enacted arbitration legislation based on the model law. It's there, you see it there on the slide. For visual impact, I've included this slide, which it shows a story. Trinidad, as you would have heard, is now the 121st jurisdiction to be recognized as Uncitrul compliant, and as of today, the number has increased to 124. Now, the short title of the Act aptly states it's an Act to repeal and replace Arbitration Act Chapter 501 to provide a modern legal framework to facilitate domestic and international trade and commerce by encouraging the use of arbitration as a method of resolving disputes. You will note I attached in my email invitation a keynote address of the Honorable Minister of Trade, wherein she identified 12 major points the Arbitration Act achieved, including the goal of developing Trinidad and Tobago as a seat of arbitration. I included that merely for context. As you well know, we often take a narrow view of how we should operate. As lawyers, we think we just need to adjudicate a case according to the law and deliver a judgment on time. I will, however, as was pointed out by the Honorable Chief Justice and the Honorable Attorney General, we would like to invite you to widen your view to consider how we might incorporate and adopt appropriate alternate dispute resolution mechanisms, arbitration as well as mediation in managing disputes in a way that it is practiced in the more sophisticated jurisdictions around the world, with the object of 1, meeting the interests of the parties, reducing delays to the parties, reducing time and costs to the judiciary or to be spending their precious resources on matters which cannot be resolved by mediation and which cannot be the subject of arbitration, thereby reducing the backlog and creating efficiencies within the judicial system. Now let's look more closely at the Act. The new Arbitration Act adopts all 36 articles of the Uncitrul Model Law with no substantial exclusions or substitutions. It comprises 10 parts covering all stages of the arbitration process, from preliminary matters and definitions, the arbitration agreement, composition and jurisdiction of the arbitral tribunal, to the recourse against an award and matters relating to recognition and enforcement of the award. It introduces new principles that we previously would not be too familiar with. Party autonomy, arbitrators' duties, and the list goes down. In collaborating with my distinguished co-presenters, we have agreed that I would touch on party autonomy, arbitrators' obligations, and consistency created between the New York Convention, now Chapter 530, and the Uncitrul Model Law, now adopted by Act Number 11 of 2023. Mr. Benjamin will deal with competence, the doctrine of separability, and equality of treatment and the right to have a full opportunity to present one's case. Madam Justice Pemberton will deal with judicial support for arbitration agreement and the arbitral process, as well as enforceability. Now, party autonomy. Typically, The parties would agree in the dispute resolution clause to their contract, the law which will govern the contract, as well as a set of rules which will govern the procedure for the arbitral proceedings. For example, the uncitral arbitration rules. Alternatively, the parties may opt to agree to use arbitration rules developed by international institutions such as the ICC, the LCIA, or a local institution if there are any. As arbitrators, practitioners, and corporate counsel, it will be necessary to become familiar with international best practices in arbitration. As, in addition to the arbitration rules, there is a body of well-developed soft laws by various institutions such as the International Bar Association, also known as IBA, that parties can agree with an arbitrator to be used in the conduct of an arbitration. It therefore allows for the arbitrator, based on the agreement of the parties, to tailor the conduct of the proceedings to the specific needs of the parties, depending on the circumstances and the subject matter of the dispute. So, for example, Section 321 provides, subject to the provisions of this Act, parties may agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Where there is no agreement under subsection 1, the arbitral tribunal may, subject to the provisions of this Act, conduct the arbitration in such manner as it considers appropriate. The power, subsection 3, provides the power conferred on the arbitral tribunal under subsection 1 includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. Subsection 2.3 provides where a provision of this Act refers to the fact that the parties have agreed, or that they may agree, or in any other way refers to an agreement of the parties, such agreement includes any arbitration rules referred to in that agreement. The party autonomy principle can be found throughout various sections of the Act, Section 13, 14, 16, 20, 22, 23, right down to Section 512. The second principle I want to touch on would be arbitrators' obligations or duties. Section 15 of the Act, which is the same as Article 12 of Uncitral Model Law, imposes a duty on the part of an arbitrator to disclose any circumstances likely to give rise to justifiable doubts as to his impartiality and independence. This will be new to our culture. Those who wish to accept appointments as arbitrators, whether your expertise is in law, engineering, or other special subject matter, you must be aware of this duty. The International Bar Association recently updated its guidelines on conflicts of interest in February 2024, and this is readily available online. This is an example of a soft law that is widely used and accepted internationally. It provides detailed guidance to arbitrators, counsel, and party representatives when considering the question of conflict of interest. Impartiality generally means that an arbitrator is not biased because of preconceived notions about issues and has no reason to favor one party over the other. Independence usually means that the arbitrator has no financial interest in the case or its outcome. It can also mean that the arbitrator is not dependent on one of the parties for any benefit, whether it be employment or client referral, or that the arbitrator does not have a close business relationship with one of the parties. Now, this topic is a very huge topic which cannot possibly be covered in an hour. And my co-presenter, Mr. Benjamin, will be dealing with the more technical aspects in terms of the case law. But a couple notes should be made. And one, this obligation to disclose occurs not only at the time of your appointment, but continues throughout the arbitration process. 2, in deciding whether to decline an appointment or to refuse to continue to act in an arbitration, arbitrators should note that it's an objective test. That is to say, whether there are justifiable doubts that would persuade a reasonable third party that the arbitrator might make a decision based on factors other than the merits of the case. So it's not whether you think you have a conflict. It's an objective test. Failure to adhere to this duty can result in a challenge under Section 15.3 if circumstances exist that give rise to justifiable doubts as to his impartiality or independence, or if the arbitrator does not possess the qualifications agreed to by the parties. And while Section 16 deals with the challenge procedure. Another fundamental obligation of an arbitrator under this new regime is to render an enforceable award. This too is a continuing obligation on the part of an arbitrator in the conduct of the arbitration. I merely highlight this point as there is considerable overlap between the requirement to be fair and impartial, to act with due care, and treating parties equally and affording a full opportunity to a party to present its case, which Mr. Benjamin is going to deal with fully in his presentation. Although Madam Justice Pemberton will deal more fully with the principle of enforceability, I wanted to highlight, because this is also new to many of us on the new regime, I wanted to highlight that the grounds upon which an award may be set aside by a court is exhaustively set out in Section 53 of the Act. And Section 53 of the Act mirrors the grounds set out in Article 5 of the New York Convention, which is now our Section 6 of Chapter 530. Similarly, Sections 54 and 53, dealing with the recognition and enforcement of awards, irrespective of which country it was made, parallels Article 4 and 5 of the New York Convention, now Sections 5 and 6 of Chapter 530. Now, in addition to adopting all 36 articles of the modern law, the new Act includes additional provisions which effectively encourages the use of arbitration by parties. It carefully considered key principles, including parties' rights of choice of representation and parties' rights to confidentiality and privacy. So these provisions include consolidation of arbitration, cost of arbitration, interest, cost of aborted arbitration, foreign representation, giving effect to a party's right of choice, privacy and confidentiality, including provision for proceedings to be heard in chambers, restriction on reporting of proceedings, and arbitrator immunity. The new Act therefore covers all stages of the arbitral award process, from arbitration agreement to the recognition and enforcement of arbitral awards, and reflects a worldwide consensus on the principles and major issues of international arbitration practice. Having said that, the key features of the new Act is that it would allow for speed and efficiency, flexibility and adaptability. It facilitates the party's right to choose an arbitrator with the requisite expertise and specialization. It safeguards the party's request for confidentiality. It provides finality. It adequately makes provision for enforceability of awards and provides consistency with the New York Convention and the ancestral model law. Given these features, all our lawyers who are involved in transactional drafting of contracts, including in-house lawyers, and there are a lot of you here, thank you for accepting our invitation. You are encouraged to include in your contracts arbitration agreements. With that, I put you on now to Mr. Benjamin. Thank you.
Good afternoon. You all look very excited to be here. Right. Okay. I'm just going to ask any one of you when I get to 10 minutes, and then when I have 5 minutes left, just give me that indication, because I probably have about 45 minutes of material, and I think I've been allowed 20 minutes. Yes? Okay. Right. So, as a lead off to those of you who are going to be putting into your contracts arbitration clauses, you all know that for there to be a valid reference to arbitration, under an arbitration clause, there needs to be a dispute or a difference between the parties. There must be an arbitration clause in the contract, and the clause, as a matter of law, must be capable of applying to the dispute, or at least on its proper construction. So what is an arbitration clause? An arbitration clause is a contractual clause evidencing agreement to refer future disputes to arbitration. Section 2.1, I guess most of you have copies of the Act available, right? Yeah. Section 2.1 of the Act says, arbitration agreement means an agreement by the party to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship. And the next four words are important, whether contractual or not. Section 10 says an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. So that's a headline of the sort of first major topic I'm going to be talking about, which is separability. So just to repeat it, you probably know it already. Your arbitration clause can be in your contract, or it can be a separate and distinct agreement. So, what's a dispute? Well, lawyers are capable of arguing about anything and everything, including the word dispute. So here are some of the examples that appear in the various arbitration clauses. All claims, all disputes, all differences, any dispute arising out of in connection with this contract, including its existence, validity, or termination. Any dispute, controversy, or claim arising out of or relating to this contract, or the breach, termination, or validity thereof. Any potential disputes. And it goes on and on and on and on and on. And for a very, 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 very long time, lawyers had massive cases, all arising out of whether they use the word arising under, or arising in connection with, or arising in relation to. So those of you who think that those distinctions are sensible, please put up your hands. Nobody? Well, I need to let you know that for a very long time you were in poor company. Many, many lawyers made a great living out of those fine distinctions. And then finally, the House of Lords, in a case called Fiona, agreeing with the Court of Appeal, said that's all utter rubbish. And what you need to do is just look at the thing from a sensible point of view. And by that I mean a commercially sensible point of view. So, this was a case in respect of which the claimants brought proceedings against the defendant seeking damages for the tort of conspiracy, recovery of bribes, damages for dishonest assistance with breach of fiduciary duty, etc. At first instance, Morrison accepted the claimant's argument that the words, and I quote, under this charter were narrower than possible alternative formulations, such as in connection with or with regard to, and therefore did not extend to any of the claims in question. Needless to say, Mr. Justice Morrison never made it to the House of Lords. The English Court of Appeal quite properly disagreed, as did the House of Lords. And that genius of commercial law, one Lord Leonard Hoffman said, in my opinion, the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, and he should have added businesswomen, are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with the presumption, unless the language makes it clear, I'm not quite sure how far I've gotten there, that certain questions were intended to be excluded from the arbitrator's jurisdiction. And if one, well, I won't read the rest of the quote. So this is known as the, well, in the case law, as the Fiona Trust principle. So it's a presumption. In other words, that whole pile of precedent and jurisprudence that made fine distinctions between how many angels dance on one particular part of the pin was thrown out and never to be used again. And by the way, this case was decided in 2010. And guess what? Within a year, no, within several months, Justice Judith Jones, as she then was, applied that principle to a case in which I acted, and in which, of course, I was trying to say that there were 7 angels on top of the pin, right? And that shouldn't be allowed. And of course, she quite properly threw me out. Oh, sorry, I should add I was being led by one Elton Prescott. So we were quite properly thrown out. But she got the law right. And as soon as she uttered those words, we knew that she was right. So the Fiona Trust principle has been applied in Trinidad literally from the moment of its birth. A more recent example of its application is a decision by Madam Justice Quinlan Williams in a case called Ridgewood Shopping against Steel Structures. Please go away and read it. I'm not going to tell you anything about it. Right. So now I'm going to come to the first of the 3 things I'm supposed to be talking about, which is separability. And I'm also going to be talking about competence. For those of you who are linguists, that's a German phrase. The phrase first comes from the German Constitutional Court, but I guess you don't want to know too much about that. Right. So let's talk about separability and competence, because these 2 things go together. So arbitration clauses, as you must be aware, are normally found in the context of contractual arrangements. And the whole point is they either form part of that contract or they're drafted as independent ones. These 2 principles, that is to say the principles of separability and competence, are 2 intervening or interconnected principles recognized at common law and now codified in our 2023 legislation. They touch upon the ability of arbitrators to determine whether there is a defense or an applicability by way of a separate arbitration clause and or their ability to determine jurisdiction. So a little bit of background. Let's just talk a little bit briefly about severability or separability at common law. It used to be thought, it no longer is, it used to be thought that the fates of the main contract and the arbitration clause were inextricably linked. See Viscount Haldane and Jurideni, and a case called, well, I won't give you the details. That principle was summarily set aside, at least conceptually, by a later decision called Photo Production Limited against Securicor. Any of those of you who were paying attention during contract classes, that should ring a bell? Yes? Okay, so I'm going to ask an occasional question just so that I can make sure you're awake. Okay, who gave the leading judgment in that case? Anybody? Okay, anybody who I taught, who gave the leading judgment in that case? Well, of course, the Venerable Lord Diplock. Okay, so Lord Diplock identified within a contract primary and secondary obligations. He had a much longer word that I will not try to pronounce because it will embarrass me, I'll get it wrong. The former relating to the performance of the contract and being brought to an end by repudiation, and the latter, including the obligation to pay damages, and, importantly for our conversation, other dispute resolution provisions. Those remain unaffected. So if the innocent party chose not to accept the repudiation, the entire contract remained in force. But if the innocent party accepted the repudiation, then the secondary obligations would in any event remain valid. So that, of course, includes your dispute resolution clause or condition. In a case in the Privy Council called Superchem against, I won't read out the long title, but it's really Algico, that should ring a bell, Lord Steyn confirmed that a repudiatory breach of contract leaves secondary obligations in place. Of course, in doing so, he followed his own earlier decision and gave a decision in my favor because I was in that case as well. This is an international principle. So it's not just confined to what happens in English common law or those parts of the world that follow the English common law. It's also applicable in the United States of America. That is to say, the same approach of separability and the survival of the arbitration clause. So that brings us to Section 19 of the Act. Section 19 of the 22 Act provides, as you can see on the screen, for the purposes of Section 1, an arbitration clause that forms part of a contract shall be treated as an agreement independent of the other terms of the contract. So the fact that it's a single clause in an existing contract doesn't matter. It's a standalone contract on its own. And that is very helpful and is a beautiful segue into my second topic for conversation, which is competence. So that's the second principle. Remember I said these were two intertwined common law principles? That's the second one, under which arbitrators are entitled to decide for themselves whether they have jurisdiction to determine the validity or applicability of the arbitration clause. Although, to be fair, their decision is provisional in the sense that either party may apply to the court to have the jurisdiction matter re-examined. And I'm sure Justice Pemberton might say something about that. The idea of competence is also reinforced. I think I've gone too far there. No. Yes, it's also reinforced by Section 1. No, I have Section 2 there. Sorry. It's not there, but I'll read it to you anyway. An arbitral tribunal may rule on its own jurisdiction. So that's worth repeating. An arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. Right? So that's quite important. If the issue between the parties is the existence of the arbitration clause itself, as opposed to the main agreement, the separability, so this is how they come together, the separability of the arbitration clause and the main agreement is not significant, as under Section 19, the question is jurisdictional only. The arbitrators are able to determine the validity of the clause under the competence principle, even though their ruling is provisional in the way that I described. And it's provisional pursuant to, I think it's Section 53. I'm not sure if it's up there. Yes, 53, too. Because an award may be set aside by the court, specified only if, if the agreement is not valid under the law, or in particular, under 53 2b, if the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law of Trinidad and Tobago, or alternatively, if the award is in conflict with public policy. So that's a long backstop that provides a limited role for the court. Otherwise, it's really all about party autonomy. I'm just pausing. How am I doing for time? Nobody's paying attention. Great. Okay, so I've got lots of other material. 10 minutes. Okay, good. So, very quickly, procedural limits on challenging jurisdictions, because that's our topic too. Jurisdictional issues can arise in a number of circumstances, but for the purposes of the new Act, there are some procedural limits on challenging jurisdiction. Those are to be found also in Section 19. So, subject to subsection 4, a plea that the arbitral tribunal does not have jurisdiction shall not be raised later than the submission of the statement of defense. 19.6, a plea that the tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitration proceedings. 19.7, notwithstanding any delay in raising a plea under either subsection 4 or 6, the tribunal may admit such a plea if it considers the delay to be justified in the circumstances. Bottom line, get on with it. Bottom line, get on with it. And I'll come back to that in a second, because really the whole of the thrust behind this Arbitration Act is really to allow individuals and entities to have their disputes resolved without delay. That's really quite fundamental. I do have a nice long digression about related agreements and disputes, but I'll just give one example, and therefore you'll be happy to know that I'm skipping over several pages of my presentation. And I just want to bring you back home. So in the High Court, oh, by the way, let me just make this plug. The Chief Justice and the Minister of Trade, and I believe the Attorney General, have said quite properly that one of the benefits of this Arbitration Act is to encourage foreign direct investment and trade, and, we could be an arbitration hub and all the rest of it and so on. That is not my personal view, which should be our priority. My personal view as to what our priorities as legal professionals, first of all, practitioners, and of course, as adjudicators, judges, whether you sit in the first instance or in the Court of Appeal, is that disputes resolution should be easier and quicker for our people. Full stop. Our people first. And if it's good enough for our people, and it's first class and it's excellent, the other people will come. That's my perspective. But that was a digression, as I told you. In the Commercial Court of England, there was a case involving the name of a company that you might recognize, Petroleum Company of Trinidad and Tobago, against another company that you might recognize, if only for the reason that you have a phone by the same name, Samsung Engineering Limited. In that case, the claimant, Petrotrin, did not properly make the distinction between jurisdiction, which is what competence is about, and error of law. The parties in that case had entered into 3 separate agreements relating to the commissioning and construction of works at the claimant's oil refinery in Trinidad, an onshore agreement between the claimant and the respondent, an offshore agreement between the claimant and a company associated with the respondent, and a linkage agreement among all 3 parties. My note says between, but that's grammatically wrong. Designed to prevent prejudice arising from the splitting of the work for tax reasons, right, between the relevant agreements. Arbitration was commenced by the claimant under the onshore agreement. The tribunal made an award in favor of the claimant, but applied an agreed damages cap of 10% of the value of the onshore agreement and refused to take into account the offshore and the linkage agreements in determining the overall value of the works. The claimant argued that the tribunal had erred on jurisdictional grounds in disregarding those agreements. Long story short, that argument wasn't accepted. Mr. Justice Colson said, look, if you had initiated arbitration in relation to all 3 agreements and tried to consolidate them, that might be a good argument. But because you chose one agreement and you had arbitration in respect of that, then it really was not a jurisdictional issue. In other words, arbitrators decide what you ask them to decide. And it was an instance of, obviously not any of the lawyers in this room, making an error strategically about what they were going to put before the arbitrator to decide. And then once they realized their mistake, try to dress it up as a jurisdictional question, which the commercial court threw them out on their air. Lastly, equality of treatment. Section 5, not quite sure where I am in this presentation, but equality of treatment. Section 5 provides the objects of this act are, this is B now, to facilitate the fair and speedy resolution of disputes by arbitration without unnecessary delay or expense. So 2 synonyms, you get the idea of the object, right? Which is to get on with it. Section 14.6 provides, in appointing an arbitrator, the court shall have due regard to any qualifications, etc., and to ensure that there's an independent and impartial arbitrator. And I think Ms. Rahman covered that a little bit. But Section 31, you can't quite see that, can you? Sorry about that. Section 31 provides opportunity of presenting its case. Now that might sound to you like common sense. It should happen on a daily basis. But you'll be surprised on the number of occasions in respect of which, for good reason at the time, that principle is not observed. And given the fact that I'm running out of time, I'll just try to give you an illustration, not about the obligations of impartiality and disclosure, but the concept of what I have described as statutory equality as embodied in Section 31. The arbitrators must make sure that they've given the parties an equal right to present their evidence, or otherwise to be heard. Secondly, the conduct of an arbitration may indicate that the tribunal has a closed mind and has prejudged the case, in which case you haven't treated them either fairly or impartially or equally. Thirdly, especially in our small jurisdiction, there's a possibility of what might appear to be undue contact between the arbitrators and one of the parties. You know, for instance, you might wander down to the Oval. I understand that that's a place where some people, not looking at the first gentleman, of course, but some people go there to socialize and so on. So one has got to be very careful about how one conducts oneself. Fourthly, the payment of money and fees. So I have an example here of a case called Andrews and Bradshaw. The arbitrator had entered into a detailed agreement concerning the payment of his fees with one of the parties to the arbitration. But the other, the claimant in the action, had refused to become a party to any agreement. At an early stage in the arbitration, a dispute arose as to how a preliminary issue was to be dealt with, and various demands were made by the claimant. The arbitrator by letter informed the claimant's solicitor that the arbitrator would determine the scope of the preliminary issue and would not be influenced by any prescription from him. The letter added, "This is particularly so in view of the refusal of your client so far to provide any cost in the matter." In the old days, that was referred as a failure to provide oxygen, but we don't speak in such colorful language anymore. The claimant asserted that the arbitrator ought to be removed for not for entering into the agreement with the other party, but on the ground of bias, in that the failure by the claimant to enter into the fee agreement had influenced the arbitrator's conduct. The Court of Appeal, any guesses as to what the Court of Appeal decided? You know, if this is one of my classes, you'll all have to answer. Tell you. Nobody? First gentleman, yes. Yes. The Court of Appeal held that on the facts, there was no bias. The arbitrator had acted properly in his decision to determine the preliminary issue in his own manner, and the strong terms of his letter demonstrated irritation with the claimant rather than bias against them. So I actually think it was a close call. However, the Court of Appeal, and I see Justice Pemberton nodding, was clearly troubled by the reference to payment in the letter, which was variously described as unfortunate, quite inappropriate, and most regrettable. So although the Court of Appeal was ultimately satisfied that the arbitrator had subsequently made it clear that there was no link between his decisions and the cost issue, and that he had acted impartially, and that he could be expected to do so in the future. What about fact-finding? And this is the last point, because 4 minutes? 4, good. Fact-finding. 1 minute left, okay, right, okay, 1 minute left. Mr. Justice Coleman, of our Clico inquiry fame, commented that there is a distinction between the process of fact-finding based on evidence before the arbitrators, that's one, and the drawing of inferences from that evidence. So while the former process is one which demands that the parties are to be given an opportunity to be heard, the latter process did not require the arbitrators to refer back to the parties for further submissions for every single inference. And let me just give you an obvious example. Suppose, as you heard from the president of the Law Association, you choose as a distinguished arbitrator an incredibly competent and very distinguished engineer. Well, you fully expect the engineer to bring to bear his or her engineering knowledge. He or she is not going to refer back his or her reasoning process to the parties if it is derived from that specialist body of knowledge. And that, as the Chief Justice mentioned in his opening remarks, is precisely why you very sensibly would want to choose an engineering/arbitrator to help you solve a dispute that had those kinds of issues. So there was a clear distinction as to what would happen before an arbitrator, on the one hand, in that circumstance, as opposed to if you were doing a matter before a High Court judge, where, of course, you'd have to get permission pursuant to Part 33 to lead expert evidence, and all of the various points would have to be adumbrated. So I'm skipping over the next 5 pages and thanking you for your attention.
Good afternoon, all colleagues and friends, and may I be allowed to adopt the protocol list and move straight into the presentation, as I too only have 20 minutes and I'm relying on my trusty timekeepers to keep me on time. As I said, it's my pleasure, But I want to apologize up front if I repeat some of what you've heard before. All right, I'll try hard not to repeat, but sometimes it's inevitable. The Honorable Chief Justice, in his address, gave a very succinct account of what the role of the court, and really and truly has left very little for me to say. But I will try. I breathe a sigh of relief to be asked to hold this dialogue with you this afternoon on this topic. And that is because for so long I have waited. So I am so happy to be here. I first became introduced to the Chartered Institute of Arbitrators back in 2012 when I attended a conference in Jamaica. And the following year saw me traveling back to endure the accelerated route to fellowship. And I see some people here who have traveled that road. And I say endure, and we all know what we mean when I say endure. So you would have heard of the journey that Trinidad and Tobago has taken from my fellow presenters. And so that you are aware of the nature of the process, the key features, principles, and concepts captured by the Act. Now, as the Chief Justice had said, the body of judges and judicial officers are ready and I dare say able, right, Justice Rajkumar? I dare say able to facilitate the arbitration process. As Chief Justice said, several of our judicial officers are trained arbitrators so that we understand the value of the process. But you may still wonder if the court is ready to assume the role in the arbitration process as envisaged by the Act. And why? So permit me to borrow the following words from Mr. Andrew Ajapio to explain why. The deliberate use of national courts in arbitration is because the same wield the coercive powers of the state to give effect to the decisions of the tribunal. We agreed? Courts are therefore useful interveners in support of arbitration in appropriate circumstances. The relation between the court and arbitration, if well interpreted and serviced, is symbolic and useful. And I feel the need to say that because in times past, the body of arbitrators thought that the courts were busybodies. Why are you all interesting yourself in getting involved in our business? That was the attitude. And a lot of times, a lot of debate was held as to the extent to which the court should be invited. So thankfully, the new act has really streamlined and delimited, I would say, or defined, I should say, the role of the court in the arbitration process. So I don't have to remind you as to what arbitration is. I think both Ms. Rahman and Mr. Benjamin have gone through that, the nature of the process, the whole issue of confidentiality, which is specifically placed at Section 58(1), which provides that arbitral proceedings shall be private and confidential. And so there's a strict duty placed on the arbitrator or the tribunal and the parties in terms of that duty. Any disclosure is considered a breach of the obligation of confidence and may be excused only under certain conditions. And the Act outlines what they are, so I wouldn't bother to go through it. But I mentioned it because the tribunal and the parties are mandated to take reasonable steps to prevent unauthorized disclosure of confidential information by a third party involved in the conduct of arbitration. And this is where the court comes in. Any unauthorized disclosure may be regarded as a breach of this provision and becomes actionable in the High Court. So that's where we come in. And that cause of action is styled breach of obligation of confidence under the Act. However, any decision under this section made by the court is subject to appeal. Now, in keeping with this necessary feature of arbitration, any court proceedings brought under this Act may not be held in open court unless there is a request from a party or if the court is satisfied that the matter should be heard in open court. And of course, the Act conditions conditions under which that can happen. When I'm presenting, I like to ask questions. So why do you think that this is important enough to be in the Act? Okay, so I'll leave it. Food for thought, because we don't have much time. I wanted to know very quickly to the courts and the arbitration process. Section 8 of the Act provides, in matters governed by this Act, a court shall not intervene except as provided for in the Act. So right away, we don't have carte blanche jurisdiction over matters. Our jurisdiction, you may be happy to learn, is defined by the Act. A round of applause for the drafters. So that the courts usually work with the provisions of the legislation in order to save the process as best as it can. Section 9 provides the jurisdiction, in other words, and I use the word very loosely, of the courts, or delimits it in sections 14, 16, 17, 19, 36, 42, 53, 59, and 60. So one wonders, well, is there anything else is there anything that we can do or we can't do? But in any event, I will try to go through, as best as I can in the time allotted, what these sections speak to. Mr. Benjamin would have gone through some of section 10 and also Ms. Rahman, where the Act recognizes two types of agreements: the agreement to arbitrate, which is a clause in the contract, or a separate agreement known as the reference agreement. The Act mandates that either of them must be in writing, and it specifies what is necessary to satisfy that requirement, so that all of the cases referred to by Mr. Benjamin are now streamlined into this section 10. All we need to know is that the agreement is in writing, and it can be culled either from the contract itself between the parties or from the separate contract reference agreement. All right? Section 11 gives the court the power to refer a party to arbitration if the action before the court concerns a matter which is the subject of an arbitration agreement. And I'm sure you understand that, because in the agreement, you may say that certain clauses in your contract will be subject to arbitration. And somehow, one party or the other may not quite read that part of the contract and come to court. And so the court will have to look at the agreement and see, is this dispute covered by that agreement to arbitrate? And if it is, then I'm sorry, you can't come here. All right? Because the court, I shouldn't say we, I'm not all of the court. The court does its utmost best to save what is the expressed intention of the parties, which is to have their dispute settled by arbitration. We agreed? All right. So as I said, the court will usually exercise the referral power in favor of the arbitration process unless the court finds, of course, that the agreement is null, void, inoperative, or incapable of being performed. And the Act also provides that an action before the court to determine this issue will not mean that the proceedings are suspended. So, all again bound up with the court's desire to have the parties, adhere to the agreement that they meant to agree to, they meant it to be bound by. Section, right. For instance, in section 14, this deals with the appointment of arbitrators. At subsection 3, if there are to be, I'm just going to be picking sections at random. If there are going to be 3 arbitrators, there's a provision as to the method of appointment. And I'll leave you all to read it. Yes, I have 10 minutes. Oh dear. All right. Similarly, in the case of a sole arbitrator, they have the court also has no, I think I'll read it. If a party fails to appoint an arbitrator within 30 days of receipt of the request to do so from the other party, or if the other 2 arbitrators fail to agree on a third arbitrator within 30 days of their appointment, the appointment shall be made upon the request of a party by the court. So the court will get involved, in other words, if they don't agree. But the court will never say the arbitration can't happen because you all don't agree. So in order to save the process, the court will take the responsibility of appointing that third arbitrator. And I think Mr. Benjamin or Ms. Rahman made reference that subsection 6 guides the court as to how to appoint that arbitrator so that the court is not left completely in the dark. And in addition, the CPR reinforces this committee by formally recognizing the role of appropriate or alternative dispute resolution, in particular mediation and arbitration. The CPR in the Guyanese Act, because this is the Trinidad Act only says including mediation, but the Guyanese CPR specifically makes mention of arbitration. So that's something for us to think about. In addition to saving those agreements, the court will become active again at the stage of enforcement. And I think Ms. Rahman and Mr. Benjamin have decided that I am to be tasked with that. And I will ask you to indulge me just a bit in setting the stage by looking at how the court system facilitates the agreement to arbitrate, both from a systemic standpoint and as between the parties. Now, how is the committee, as I call it, between the courts and the arbitration process effected systemically? One needs to start with the provisions of the CPR, of course, the overriding objective, and I think the Chief Justice made mention of the overriding objective and how we deal with cases justly and so I don't need to go through that, right? One of arbitration's recognized values is that the process best serves specialized subject areas. Again, the Chief Justice alluded to that. He spoke of that in the construction sector, which I quite appreciate. During my time in practice, I participated in 2 arbitrations when dealing with construction matters. And I could tell you that it was a great advantage in both instances that the sole arbitrator was a subject matter expert. So I am sure some of you can recount a case or 2 as judges or judicial officers in which technical issues abounded, and you may have welcomed an expert to guide you in your deliberations. I must confess that happened to me as well on several occasions, and I made use of the expert. But for me, it makes more sense to speak the same language of the dispute to a party neutral who speaks that language as well. What I mean is, if you can speak to the person who can understand and appreciate the nuances of the area far better than one trained in law alone. It would not be a situation of speaking French to a Dutchman. That's how I put it. You're supposed to laugh. There may be an occasion, though, where an arbitrator, once chosen by the parties and so appointed, may be unable to perform the duties, or of delay as is stated in the Act. Undue delay rears its ugly head. In such circumstances, his mandate terminates if he withdraws from office or the parties agree on the termination. Now, in the event that there are such difficulties, Section 17(2) empowers a party to approach the court to decide whether there is a termination of the mandate, and that decision is final and not subject to appeal. I did have something on jurisdiction, but I think Mr. Benjamin dealt with that so exclusively and explicitly that I don't think I need to go through that again. Do I, Mr. Benjamin? No. So let's look at 4 minutes. Oh dear. The enforcement of the arbitration agreement, and we will concentrate on the final award. A final award may be recognized by its nature in that it covers the key or most important decisions referred to the arbitrator. The award produces important consequences that impact on the rights of the parties and essentially is intended to put an end to the dispute between them. In other words, the award affects the rights of the parties. The court will be guided by the arbitration agreement, but in spite of that, but in addition to that, the courts have been reluctant traditionally to intervene in the process. The role of the court is one of oversight and review, and the court ought not to involve itself in deliberating substantive issues between and among the parties. At the same time, the arbitration process should not really be left as a rudderless ship. So some of the, I think, all right, let me look at, all right. So I'll go straight to 53 because I probably just have 1 minute left. And Section 53 sets out how the enforceability of the award may be compromised. And the party making the application to either set aside the final award must prove a party to the arbitration was under some incapacity, or the validity of the agreement with respect to the agreed law of the arbitration is wanting. There was some procedural irregularity, such as the party against whom the award was made was not given proper notice of his appointment of the arbitrator or of the arbitration proceedings. And I think Mr. Benjamin dealt with this. One party was prevented from presenting his case, and it all went to fairness. The award deals with a dispute not contemplated or falling within the issues to be dealt with by the panel as agreed by the parties, or the award contains decisions on matters beyond the scope of the submission to the arbitration, or the composition of the panel or procedure used was not in accordance with the agreement of the parties, unless such agreement was in conflict with a provision of the Act from which the parties cannot derogate, or it was simply not in conformity with the Act. and the award has not yet become binding on the parties, or has been set aside or suspended by the court of the country in which or under which the law of which the award was made. And just recently, the Court of Appeal, of which I was part of the panel, handed down a decision, Christian Christensen, where that point was raised, in that the parties had received the award from the arbitrator, and both parties challenged the decision on a ground of law, errors of law. One party made certain interim payments to the other, pending the outcome of the proceedings. So, although both parties had the same ground of objection to the award, one party attempted to enforce the award before the question under review had been determined by the trial judge. The trial judge refused to entertain the application, and that's how it came to the Court of Appeal. The Court of Appeals remitted the matter to the trial judge for continued hearing and dismissed the appeal. In addition, the court may well find that the subject matter of the dispute is not capable of settlement by arbitration under the laws of Trinidad and Tobago, and I think Mr. Benjamin mentioned this, the award offends public policy. The one thing I will say here, if one looks at the Guyanese law, they will go into some detail as to what public policy entails, and it may very well be that we may want to look at it to see if we need to do that here. Well, yeah, I understand, but it's a guide. It's a guide. Now, the court has also been given the jurisdiction to sever the offending parts of the award so as to save the award, reflecting the final and binding decision on the matter submitted to the tribunal for determination. Right? There are cases that came before the court dealing with delays in making the award, and of course the court will look at each case and decide it sui generis. Now, under Section 29, there are conditions under which the court may refuse applications for recognition and enforcement of foreign awards, and I wouldn't go into detail about that. Section 54 enjoins the court to recognize as binding any arbitration award, as I said, irrespective of the country under which it was made. And they set out the grounds for refusal, which are very much validity, party incapacity, and all the other issues that I mentioned above. And the procedure, of course, is detailed in Section 4410 of the CPR. And the only other thing although there's no express provision in the law, the general rule may be that the time for making an application to set aside the award, the general rule may be that once the time for making the application to set aside the award has expired, enforcement proceedings may begin, provided everything is in order. I just want to mention, Ms. Rahman, I think you spoke to the IBA provisions in terms of the conduct of arbitrators, and I would just like to put in a plug here that even though we have the IBA standards, that perhaps the arbitrators in Trinidad and Tobago could think about establishing a code of ethics to which they may be bound. Okay? So. Yeah, I know CIARB has a code of ethics, but our chapter needs to do what is necessary. Okay? All right. Well, thank you very much for listening.
like to move straight into the Q&A session as soon as we are mic'd. And by we, I mean Mr. Benjamin, Justice Pemberton, Mr. Gurley, Senior Counsel, if you all could facilitate being mic'd. We would ask you to remain seated. So we have, right, okay. Okay, we're feeling test questions. The mics are on both sides.
or comments?
Hello. This question is to any member of the panel, but Sean, you just referred to section 53 to be 1. Subject matter of a dispute is not capable of settlement by arbitration under the law of Trinidad and Tobago. I was wondering what types of matters are not subject to settlement by arbitration.
Public law. Judicial, public law. Anything that would be in the nature of administrative action, judicial review, those wouldn't fall really in the sphere of commercial.
Once you have an arbitration clause in a contract, is there any way you can get around it so that you don't have to go through arbitration?
Well, yes.
No.
Well, it defeats the purpose of the exercise. But clearly, if it's contractual, the parties can agree that that contractual clause no longer binds them. So the answer is yes, you can. It's very simple. But it would have meant that we'd have spent a lot of time together.
Yeah. It's
Not
kind of
very
unlikely.
fruitfully.
Yeah, but that kind of dispute will hardly, are you hearing me?
Yes.
Yes, but that kind of dispute will hardly get to the court if both parties are agreeing that we no longer want that party to be part of our agreement. Then who is going to come to court and do it? So how will the dispute go to the court?
Yeah, but the other side may not agree.
Yes.
The other side may not agree. And
So if
when
I
you
could,
file an action, they
Yeah.
will then make an application under Section 11, and you will be thrown out by the court.
I had a section in my talk which there just wasn't enough time to share with you, in which it was really a discussion around multiple agreements in respect of which some of those contracts contained no arbitration clause at all. So that would be one example. And so there is a debate in the case law as to whether in a circumstance where you have multiple agreements, one or other, only one contains an arbitration agreement, how should the arrangement be construed by the court? And so the case law suggests that what you look to try to discover is what the judges, in fact, Lady Justice Card describes as where is the center of gravity when you look at the contractual arrangement as a whole. So if you look at it in its entirety, if you can fairly come to the conclusion that the parties intended, even though there is one aspect in which there is no agreement, for the whole of their arrangements to be resolved by a tribunal, then that's a perfectly legitimate conclusion to come to. So a circumstance where arbitration clause in one contract, not in another, construe them together, as long as it reflects a relationship between or among the parties.
Go ahead.
Hi. Yes, in the definition section of the Act, under the first definition, it refers to a person called an arbitrator. Can you tell me why in the Act it has omitted to define who an arbitrator is, or who should be an arbitrator, or what should be the qualification of an arbitrator? Because if the public is out there hardly knows the qualifications of an arbitrator, but if they have a reference to it in the Act, wouldn't that help?
Well, first off, the definition of arbitral tribunal is taken straight off in Model Law, Article 2B. If I might explain, we have in this legislation adopted the UNCITRAL model law, and this is the definition which we are using. In international, it really isn't a mystery. Parties are going to have lawyers in any event who can guide them what an arbitrator should or should not be, and there's always the Trinidad branch Chartered which provide on their website means of arbitrators which you can search on Google search. So it's not really that difficult.
That would be true. You mentioned that you could actually choose alternative rules other than your natural rules. So
No. Don't. The model law is the law. In addition to that, there are UNCITRAL arbitration rules which are supplemental to the Act. So it's an accompaniment to the Act. So it works together, and that deals with procedure.
So then that leads to my other aspect, which is the cost of arbitration. By using certain rules, right? And if we don't have probably we're guided only to use certain arbitrators. And I know I've been involved in this and so forth, member of the CIARB. And I know how expensive it is for to hire and have an arbitrator. Some of them don't even reside in Trinidad, and it's very costly to have them. I wonder if you have some sort of scale of fees that
Well,
small man to be able to access arbitration, because being in the construction industry, the ordinary homeowner, is not a very wealthy person.
Yeah,
and we have to understand, if we want them to have an access to arbitration, even through construction, and let's not even go to expert witnesses, because I can tell you that the cost of an expert witness is almost 3 times the cost of the arbitrator on the panel. But how does a small man be able to access arbitration at an affordable level?
You want to answer that? Arbitration isn't.
Arbitration can become less expensive by reason of its expedition. The opportunity of having a chosen arbitrator who is familiar with the subject of the arbitration would be able to sift through the chaff and come to the heart of the matter, and more likely get the decision right. So the question rules that govern arbitration, whether you select the UNCITRAL model rules or the CCI rules or whichever rules you select, there are a lot more accommodating to expediting the hearing than the rules of the Supreme Court, which are more complex and tend to complicate the matter rather than simplify it.
I would also add that in the arbitration example that you have in mind, right, the average homeowner has an issue, not happy with the contractor, right? That might be something that can be dealt with without any oral evidence at all. In other words, if you choose the right arbitrator, in other words, somebody with competence, so I'm going back to your first question, then you are going to get a result from a competent, expert person on a much faster basis, precisely for that reason. So the premise that you started off with, which is that arbitrations are expensive, I'm not sure that I accept it, but even assuming that that is so, in addition to what Mr. Greeley mentioned, choosing the right person is going to also facilitate your outcome in a way that, or at a speed that the courts cannot yet, I remain hopeful, the courts cannot yet match.
Thank you very much.
You're welcome. Mrs. Sweet?
Yeah, I don't know if I could just make so bold as to add something to an answer to the question of Mr. Outridge, our quantity surveyor, which is that there is no specific qualification in the law required of an arbitrator, and that the parties could agree any person whom they both select, or any panel that they both select, to be the arbitrator, notwithstanding that perhaps they're not sanctioned by CIARB, or they are not on your list. In other words, I want to make sure that I'm correct in that yes, you can choose whoever you want to are, and the law does not prescribe any specific qualification for the arbitrator. Although, of course, it's best to have somebody who wants to move the trading as well.
I just want to add that we must remember that
and they can get guidance on that from
because remember, these are all services to the court utilizing third-party neutral. The main characteristic of the arbitrator is that it should be neutral, and that the parties both agree that this is the person or this is the panel to hear their decision.
Yeah. Of course, you know, that's your choice. But the question that I wanted to ask was that under Section 32, the Act provides that the parties can agree on the procedure, and where there's no agreement on the procedure, the the arbitral tribunal may conduct the arbitration in the manner that it considers appropriate, and that they have the power to determine admissibility, relevance, materiality, and weight of any evidence. But now, if you have an arbitrator who's not an attorney, let's say an engineer, or a panel of engineers, and you have not had you did not put on the panel of arbitrators. And my limited experience has been that non-attorney arbitrators quickly get thoroughly overwhelmed by panels of attorneys on each side who attempt to impose on them the procedure of the court. What I wanted to find out is that what the law is, if it is that someone who is aggrieved by, or at least the attorneys advise the party within the arbitration that the arbitrator has not followed a particular rule of evidence, whether that is a ground for reviewing the award.
Yeah.
Let's say hearsay, taking hearsay, or you didn't put in your documents strictly according to the type rules of evidence and so on. Would that be a sufficient challenge to the award to take it reviewed by the court or satisfied by the court?
Not in my view. Not in my view. The whole purpose of the provision that you have in mind, especially 32, right? 32.3, is that that's a matter for the tribunal. And I certainly, in my experience, I've done arbitrations before, arbitrator Gilly and other arbitrators. And the absolute pleasure of it, not to mention the speed, was the fact that we never got bogged down, with great respect to you, my colleagues, in that foolishness of admissibility and hearsay and all that. In other words, at the end of the day, we were asking the tribunal to make a decision as to what was more cogent or not. And that's ultimately how we did it.
Well, I suppose you could get into the realm now of persons not being given an opportunity of presenting their case. If you get really extreme with not following, simple processes of, for example, giving somebody an opportunity to be heard or to reply to a document, I suppose it can get into the realm where the equal treatment of the parties may be able, or the question of equal treatment of the parties may be able to divert a dispute into the court if somebody feels so aggrieved by the process that they claim that they've not been treated equally. So I guess it's a question of degree of the departure from all of our process.
Yeah, but it would have to be quite egregious, is the point. And the flexibility that ordinarily experienced competent tribunal exercises normally means that it's for the most part not an issue.
Also, now that we've adopted the ancestral model law, we have to operate international best practices, and we don't have to reinvent the wheel. There are well-established arbitration rules, whether it's the UNCITRAL or the ICC, which is what I referred to, that would assist the parties very quickly on what, and those rules align well with the UNCITRAL model law.
Yeah.
You have your procedural law, then there are a body of soft laws. So in addition to the IBA rules on conflict of interest, there are the UNCITRAL rules in relation to organizing proceedings. And the parties at the first hearing can agree that. So it's very, when in my presentation, I pretty much was telegraphing to the audience is that we have as attorneys have to become familiar with the international best practice, and it's not very difficult to find it. And hopefully in the future, the arbitrations could be very, very easily well structured, because we don't have to reinvent the wheel. It's all there.
Thank you.
Okay.
Hi. Hi, good afternoon. My name is Atiya. I'm a student at Fielding Law School, and I just have a question for Mr. Benjamin. More or less, I want an explanation, a better explanation, if I may so ask this question correctly. Section 19, that says an arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. So, I am thinking that if a party is objecting and saying that you as the arbitrator don't have jurisdiction, let's say it's a matter with regards to construction or engineering, and the parties are saying that you don't have jurisdiction, is it that the arbitrator can proceed to rule on itself and say that they do indeed have jurisdiction, sorry?
Yes, that's exactly right. So it's the obligation of the arbitrator or the arbitrators to resolve any issue or dispute that's raised before them or him or her as to the extent of their jurisdiction. Absolutely correct. So just to give an example, let's suppose the arbitration agreement concerns engineering, yes? But you want to bring an agricultural dispute. Well, and I don't have jurisdiction. It's not that I can't, but you would have to put that before me by way of an arbitration agreement and by way of submission. So that's a straightforward example of what's inside the basket and what's outside the basket.
Because I was thinking that, okay, so in that instance, if in terms of an agricultural dispute, an engineering arbitrator says, well, I do have jurisdiction in that circumstance, then we have an appeal issue.
Well, it will be set aside.
It will be, okay, good.
Yes, pursuant to Section 53.
All right, thank you.
Because you have to remember too that the arbitrator derives his jurisdiction from the agreement between the parties. So you can't come on the day to present something else that the other side hasn't agreed to, and just sit, or the two of you sit down and say what, and then you present it to the arbitrator. He doesn't have that expertise. He doesn't have that competence.
Thank you. So it starts with the arbitration agreement.
Yeah. What are the terms of the arbitration?
Thank you.
How are we doing for time? It's 4.
Right, 4 o'clock. Mr. Nanga, you have any questions?
Is it 4? 5 minutes? Yes, okay.
Yes, we are.
Any other question? What time is it? 3:58? No, no, no. Okay.
Okay.
Yes.
I have a question for the audience. Do you think that the court's oversight role has been properly addressed in the Act?
Good question.
Would you like to say anything more?
Or less.
Or less? That was a hard exam question. It's a hard question. All right, well then I'll say food for thought.
Yes.
Until next year.
Well, until October.
Yes.
I'm just making a little plug that the Caribbean branch of CIARB will be having a conference, and we will send you a save the date flyer in our thank you email for attending. Okay, I'll put you on to Ria now.
Good afternoon, all protocols observed. On behalf of the Chartered Institute of Arbitrators, Trinidad and Tobago Chapter, I extend my heartfelt gratitude to all our distinguished speakers and panelists. The Honorable Attorney General Senator Reginald Moore Senior Counsel, the Honorable Chief Justice Ivor Archie, ORTT, the Honorable Madam Justice Charmaine Pemberton, Justice of Appeal, Mr. Dennis Gurley, Senior Counsel, Mr. Ian Benjamin, Senior Counsel, Dr. Lynette Sivaran Sweet, Senior Counsel, and Ms. Salma Rahman. The discussions today were insightful and engaging. Your expertise has undoubtedly deepened our understanding of the intricacies and objectives of the new Arbitration Act. I also wish to express my sincere thanks to our esteemed attendees. The First Gentleman, Mr. Kerwin Garcia, Senior Counsel, all members of the judiciary, judges, masters, registrars, representatives from the legal and business communities, governmental, non-profit, and professional organizations, and the media. Your presence and participation have been invaluable. Although our chapter chair, Justice Dr. Anthony Gaffur, could not be here today, he has conveyed his support and enthusiasm for the progress that we are making with this new legislation. A special thank you goes out to all those who played a crucial role in organizing this event. I am grateful to the dedicated members of the judiciary's team, the Hugh Wooding Law School students, and our chapter executive members, Latoya, Salma, and Edward, whose hard work and dedication have made this event a resounding success. By tomorrow, a survey will be distributed, and we would be grateful if this can be completed. Before we conclude, I invite you all to join us for some light refreshments. And as we approach the start of the long weekend, I wish you all a safe and enjoyable break. Thank you.